Well, hello, everyone. Welcome to our conversation on empowering seniors with celiac disease, advocacy strategies, and legal rights. Today, we are going to focus on what has been a traditionally overlooked but key component to our celiac community, and that is senior citizens. My name is Chris Rich. I am the CEO and Executive Director of the National Celiac Association. Thank you for putting some time into your busy schedules to join us this afternoon for what I feel is going to be a very important discussion. Our mission at the National Celiac Association is to educate, advocate, and empower individuals, families, and communities affected by celiac disease and non-celiac gluten sensitivities. This includes a wide array of initiatives focused on specific demographic groups, including our ROC program, which is Raising Our Celiac Kids, that directly assists kids and their families, and pertinent to today's conversation, our Supporting Celiac Seniors initiative. You can find more information about what NCA does for our community, these aforementioned programs, and other initiatives at our website, which is nationalceliac.org. So let's go over some quick housekeeping items before we introduce our distinguished guests for this session. We want today to be an equally an educational event as well as a helpful discussion for you. So you're welcome to ask general questions through the Q&A feature, which is located there in the bottom section on your Zoom screen. Today's format is going to include a presentation from our speakers, Andrew Rozynski and David John Hommel. Following their presentation, I'll be inviting Carla Carter, who is our Director of Outreach and Programs for the National Celiac Association, to join us for a Q&A session, which will address some of those questions that you've previously sent in, as well as the questions that you submit through that Q&A box. The wonderful staff here at NCA will also be answering questions as they come in, so we can hopefully address as many of these as we can. Closed caption is also available by clicking on that CC button, which is also down there at the lower portion of your Zoom screen. The discussion is also going to be recorded and available for viewing on our website and our YouTube channel here in a few weeks. The site address again, nationalceliac.org. We're found on YouTube by searching National Celiac Association. So you'll also be receiving a mail from NCA that's going to have a link to the recordings included with that email. So look for that and the link to hit your inboxes here sometime in the next couple of weeks. So enough of me talking. Let's get to the festivities and let's get started by introducing our presenters for today's discussion. Andrew Rozynski is a law partner and the co-director of the Eisenberg and Baum Law Center for Deaf and Hard of Hearing. He has a strong national presence with admissions to over 40 federal, district, and appellate courts spanning across more than 25 states. In his career, he has obtained over 25 favorable verdicts from juries, judges, and arbitrators. Andrew has argued dozens of cases in appellate and trial courts throughout the country, including the United States Supreme Court. A testament to his influence, Andrew has handled numerous nationally significant cases across varied contexts and has worked closely with and maintains good relationships with other civil rights advocacy organizations, including the United States Department of Justice, NAACP, ACLU, and National Fair Housing Alliance. David John Hommel is also a law partner. He runs the disability rights practice at Eisenberg and Baum. When he was recently promoted to partner, the firm described him as a strategic advocate and an architect of hope, building bridges to access and equity for those who have long been marginalized. Last fall, David John won a federal jury trial where he presented the closing argument, and the case helped to expand the availability of financial compensation for any plaintiff who is discriminated against on the basis of disability. So both of these gentlemen are people who we are very happy to have on the side of our community. So Andrew and David John, welcome. The floor is yours.
Thank you so much, Chris. Really, really appreciate your organization having us here today. And we are so excited to educate all of our guests here today on how they can be strategic advocates for themselves and the people that they care about through the law and advocacy. So let's start sharing my PowerPoint. And so what is this presentation about? So really what we want you to take from this presentation is these objectives that are listed on the screen. One, we want to make sure that you understand the great impact that celiac disease has on seniors in senior care settings, whether that be independent living, assisted living, nursing homes, acute long care settings, hospitals, etc. we want to teach you about and educate you about your rights under the ADA and the Fair Housing Act as well, because the protections are numerous between the two. We also are going to give you tips and strategies to effectively advocate for yourselves and others in these various settings to make sure that you really can protect yourself and others if you have to fight for your rights in those types of settings. And we want you to show you how to build and leverage networks so that you can use resources that are at your fingertips to ensure that you can get and meet your objectives. And lastly, we're going to go over how you can navigate these complicated situations with healthcare and the legal systems and do so effectively. So with that, go to the next slide. So, going to understanding a celiac disease. So, as we know, celiac disease is an autoimmune disorder, and it is qualified as a disability under the various laws. And so, because of that, you actually have a lot of legal protections, which my partner David John is going to go into. And so it's really important that when you're going into these settings, you have in the back of your mind that I'm or my loved one is protected. And if we can't come to an agreement, a compromise to ensure that me or my loved one has access to safe food while in these settings, that the law is going to back me up on that. And so always go into these situations with that sort of mindset. And when we give you more of these tools, you'll understand how well you are protected in these situations. And two is not just about how well you're protected, but how to effectively advocate for yourself and your care. And we're gonna be providing actually like tips and tricks and things tangentially that you can do in these types of settings so that if you ever have to get to the step of say a lawsuit or something like that, that you've already exhausted all of your resources, whether it be working closely with these organizations, making the proper requests, educating, using your support networks. You've exhausted all of those, and if you have to get to that point, you'll have all your ducks in a row to create a very successful case if you have to get to that point. But hopefully you'll never have to get to that point. So with that being said, I want to hand it over to David John to talk a little bit about the law.
Hello all. I'm beaming in from Queens, New York. Before I forget, I want to thank NCA, especially Chris, Carla, and Kim for being gracious partners and collaborators and co-hosts. And I certainly want to thank you all for coming here this afternoon. Now, I can tell you as a nice disclaimer, I previewed my talking points before my 2-year-old daughter, and in her words, it was spellbinding. So I hope that take two is just as good. But as Andrew teed up, what we want to do today is go over a crash course of the Americans with Disabilities Act, which really stands as a starting point for a lot of other city, state, and other federal laws. We also want to plan for the worst and hope for the best. We want to empower you, or as Chris said, educate, advocate, and empower you to understand what your legal rights are, how to connect with others to build support, how to navigate the Byzantine complexity of the legal system and the healthcare system. I mean, overall, Andrew and I are here together as hopefully carrying a banner of hope to let you know that you are not alone, that you have legal rights, you have protections, and we're here to give you a brief snippet on everything that you can do to protect yourself. Now, let me start with the Americans with Disabilities Act. The goal of this federal law, of course, is to end exclusions for all of those with disabilities. And here specifically, we want to make sure that our seniors with celiac disease or anyone with celiac disease is included in all facets of life. The ADA itself is broken up into what's known as different titles. For example, Title I deals with employment, Title II deals with public entities such as the state and local governments, and Title III involves what's known as public accommodations, private businesses, many hospitals, senior care facilities. And in addition, there are many other federal laws that relate to the ADA. For example, there's Section 504 of the Rehabilitation Act. There is the Affordable Care Act, or as we have here on the slide, there's the FHA, which stands for the Fair Housing Act. As a starting point, to win a lawsuit under the ADA, specifically Title III, a plaintiff would have to show three things. I think it's a good grounding point for us to kind of understand what your rights are. First, we have to show that the individual is disabled within the meaning of the ADA. Second, that the defendant entity owns, leases, or operates a public accommodation. And third, that the defendant discriminated against the individual based on his or her disability. And relatedly, the FHA offers similar protections. So what's super important? Let's start with the first element in legal jargon, the disability. So the ADA defines disability as a physical or mental impairment that substantially limits one or more major life activities. There's no requirement for a diagnosis per se. The statute itself doesn't talk about a diagnosis. It simply focuses on whether there's that impairment that substantially limits one or more major life activities. And here, that's where celiac disease comes in. Of course, celiac disease is an autoimmune disorder that affects the major life activity of eating, and it can affect major bodily functions of the immune, digestive, bowel, and neurological symptoms. Certainly, if someone were to eat gluten, that would affect your entire body if you're an individual with a disability. Now, one thing you may be thinking is, David John, couldn't a defendant entity like a hospital or a senior care facility say, well, so-and-so doesn't need to eat certain items of food here. They could subsist on plain chicken, plain fish, and so on, and they could avoid the effects of consuming gluten. Well, in 2008, after a series of Supreme Court decisions that narrowly interpreted what a disability is, Congress amended the ADA to overturn those decisions in what's known as the ADA Amendments Act. And the most important takeaway from the ADA Amendments Act is that we need to consider impairments in their unmitigated state. Next, what we really want to focus on is a few inquiries. First, when you ask for items that are gluten-free, or whether that's because you want to be accommodated, or whether you're asking a senior care facility, for instance, to modify their existing policies to allow for gluten-free options, we're considering whether the modification or the request is reasonable. And an important point is having a shared experience of food can often be the whole point of going to a senior care facility on a day-to-day basis, where you want to mingle with other residents, you want to talk to folks, you want to say, hey, I don't think that this was as spellbinding as David John's daughter said it was. You want to break bread over the meal. I mean, certainly it's around lunchtime in a lot of different folks' areas right now. And we want to get together and talk and connect and be with one another. And that's an important point of the ADA, is it guarantees, cutting through all the legalese, a like experience. Let me give you a few examples. For example, imagine someone in a wheelchair. If they're going to the movie theater, they don't expect to simply be cabined to the front row. And certainly they want the opportunity to sit with family and friends, because that's what other moviegoers expect. Likewise, imagine you're going to Starbucks to get a cup of coffee, and you're in that wheelchair, and other people at Starbucks are able to face anywhere they want. But those with wheelchairs are kind of sectioned off, and they have to face the wall of the store. Well, that's not a like experience. And in addition, imagine if you are deaf or hard of hearing, and you want to go to a theater production, and a theater company only offers one performance a month in which there's closed captioning or an interpreter. That wouldn't be the same as other folks who go to that theater and are able to experience a wide array of options of different show times, whether it's on a daily basis, a weekly basis, or so on. So with that, what we want to really focus on is laying the groundwork in case you need to file a potential lawsuit, or what's known as a demand letter, in which you can contact a senior care facility or a hospital and advise them of your dietary needs and what you need as an accommodation. Because again, a gluten-free diet is the only way to combat celiac disease, and it's important for you to educate the other entities to make clear what your rights are. And again, that's not to presume that the other entities need to be educated by you, but oftentimes, as we've seen, these facilities are unaware of your vast and broad protections under the ADA. So you're merely telling them what they should already know. And what we want to do throughout the rest of this webinar is give you helpful pointers and tips to do so. With that, let me turn the floor back over to my partner in crime, Andrew, to talk more about effective advocacy strategies as we continue to navigate this topic.
Thank you so much, David John. Yeah, so now, now that we got through the legal mumbo jumbo, right? It's like, well, how can I put this into practice? What can I do to in real life when I'm faced with a situation? How can I advocate for myself? I mean, no one wants to just call up a lawyer every time there's a problem. So here we're going to go over some of these like clear and easy to do tips and to ensure that you are effectively advocating for yourself. So first is if you're looking for independent living, assisted living, nursing homes, etc. Number one, do your homework. Talk to others that may have celiac disease or have experience of their loved ones in these types of settings, and find out what facilities are accommodating, what facilities are horror stories. Obviously, if you have people that have already have great experiences and you don't have to actually fight the good fight just to get these services, that's one way of just foregoing all of this stuff. But if you get into a situation where you want to go to a specific facility and you're getting a little bit of resistance, here are some tips. Number one is clear communication with the facilities. So what you want to do is you want to make sure that you ask the pertinent questions. How is your food prepared? How is it served? Do you have a gluten-free certified kitchen? What steps are you taking to ensure that the food is not cross-contaminated or is safe? Do you provide equal meal options? Is everything on the menu? Can you make it? Is there a gluten-free alternative? Or and really, ask a lot of those questions, not just of the marketing rep who may just be trying to say whatever it is that they want to say to you to get you in, but actually talking to the administrator or the CEO or the dining director of that facility, and really sit down, have those conversations, ask those tough questions, and make sure that they actually know what they're talking about. And if they don't know what they're talking about, if you're their first experience, I would really advise to see if they're open to education and providing resources and having those resources set up. These are organizations that can help certify you as a gluten-free kitchen. These are things you can do to ensure that the food is not cross-contaminated, etc. Actually giving them education, if they're receptive to that education, ensuring that they actually follow through with what they say they can do. If they say, sure, we're happy to do this and we'd love to have you here, making sure that you get that in writing, whether it be by email, by contract, by something, that you guys are on the same page. Because unfortunately, later on you go there and then it becomes he said, she said, and they say, oh, I never promised that, or I never did that. And it's really important. And that's with anything that when you're communicating with facilities, is to make sure that if there's a meeting of the minds, there's an agreement, everyone's satisfied, that you get that in writing. It's really, really, really important. And then I get people that come to me and say, like, well look, I don't have a choice. I broke my leg and now I'm in a nursing home, or I'm getting older and I need assisted living and I need one close to my house. I can't do all this homework. I need to go to this specific facility and I'm already there. And what do? I'm already there. We've never really had this discussion, and I'm just subsisting on plain fish and grilled chicken every day, and that's my life every day. What do? One is, you want to go to the again, highest level, administrator, dining director, the top person you can, and make a specific request, and do so in writing to make sure that you're very clear about what your needs are, what you expect, and what to do. Now, I'm going to go over some of the common responses when people want to, deny things to people with celiac disease. One is like, oh, we don't do that here, and so you need to, find a place that will deliver you your own food, because we don't do that here. Or two, oh, if you do that, you have to pay extra for it. So yeah, we can do gluten-free, but you're gonna have to pay an extra $400 a month for that. Under the law, they cannot charge you more for accommodating your disability. So if they're doing that, that's actually a violation of the law. So that's something to think about as well. Also, the other things that they say is, well, we do provide gluten-free options, because we serve, broccoli on this day, and we serve grilled chicken on this day. So you have options to pick from. But really, what the law provides is having that equal access and like experience that David John was talking about. And so that's really important to know that if others in your community get to enjoy all these things, that you should have, to the extent practicable, equal access to similar type of items, so that you can enjoy those as well. And that's what inclusivity and equal access looks like under these laws. So with that being said, I'm going to turn over to David John to provide additional tips and whatnot in these advocacy efforts.
Thank you, Andrew. Folks, as you'll come to see, I'm often a cover version of Andrew, just repackaging similar things you heard, but it's important to do so here because I want to emphasize a few things that Andrew said. First and foremost, we want to document as much as possible. I think it's always good to look at a lawsuit and think, if you're on the eve of trial, if you could reverse engineer where you are right now and go all the way back to the beginning, what information would you like to have had? What individuals would you have liked to have spoken to? Questions, which documents would you have liked to uncover? And that's important. So when you're looking at a senior care facility, or you're going to any type of entity, whether it's a hospital and beyond, a rehabilitation center, it's important to make clear requests. What's important under the law and what juries and judges look for is an individual making a clear request for accommodations, and then in turn, often a clear denial or a clear rejection by the defendant entity. And as Andrew said, you should alert everyone from top to bottom, those in the marketing department, those who are in the dining services, those who are administrators, even frontline staff, because oftentimes you have administrators who support and are familiar with policies that support the ADA, the FHA, and other city, state, and federal laws, but it's really those frontline individuals, those who are servers in a dining room, or those that you interact with on a daily basis, let's say even in a hospital, nurses and doctors, who may be unfamiliar with the ins and outs of what the ADA and related laws provide. So what you can do is you could advise all those types of individuals, look, gluten is pervasive. It's challenging to maintain a gluten-free diet. The only way I can maintain accepted treatment is a strictly gluten-free diet. And ask questions. How do you avoid cross-contact? Do you have separate utensils, separate dishes for gluten-free food? Gluten is often a thickener and a binding and an anti-caking agent. How do you handle such things? You could ask specific questions, test their knowledge. What grains contain gluten? Does quinoa, buckwheat, vinegar, soy sauce, spices? Do you check websites such as glutenfreewatchdog.org to understand if there's mislabeled gluten-free products in the marketplace? And as Andrew said, before you sign a contract, for instance, with a senior care facility, make sure you have all this information documented. You have emails, you have written correspondence in some fashion from the administrators and the pertinent individuals, whether it's the director of dining, the heads of the marketing department. Go as far up the chain as you can and even memorialize information yourself. Another point about lawsuits, there's something known as a statute of limitations, or what's commonly referred to as a limitations period. And that just simply means courts want to have a clear starting point of when you could bring a lawsuit and an end point. Oftentimes it's 2 years, 3 years. It's often contingent on what your state specifically provides. So the ADA will change depending on your jurisdiction. So in fact, even if you don't have a situation that's occurring now, if you had something that occurred 1, 2, even 3 years ago, you still may have the ability to file a lawsuit if someone had glutened you or poisoned you because of cross contact, because of a misunderstanding of labeling, and things of that nature. But with that in mind, the passage of time in a lawsuit can often be very slow. So with this documentation, whether it's getting documents from the defendant entity or you memorializing things yourself, keeping a diary or a journal and listing down dates and times, to whom you spoke to about the issues and what you spoke about, that would be supremely helpful for you to protect yourself in case a lawsuit is necessary or some type of other advocacy is necessary to make sure that you can avoid contamination from cross contact or mislabeled items, or frontline staff and administrators who just don't understand what you need despite as much information you provide them. Now, at this point, I want to turn over, because a related topic is kind of building and leveraging support networks to make sure your rights are protected. Andrew?
All right. Yeah. Thank you, David John. So yeah, building support networks, and that can be internally in the organizations that you're working with, or it could be outside entities. So whether there's a lot of talk about, like, if I'm in a hospital, or if I'm not, I can't effectively advocate for myself because of whatever medical condition that I'm going through. What am I supposed to do? How am I supposed to protect myself if for whatever reason, say I get dementia, or I can't successfully advocate for myself? And you want to start thinking about that. If you have celiac disease, or someone that you love does, it's important that they prepare for that situation. Having someone who has power of attorney, or having a healthcare proxy, to make sure that your wishes of getting a clean gluten-free diet are being met, and building that support network now, because many of us do not know when that day will happen where we cannot fully advocate for ourselves, and we need others to do so on our behalf. So having those conversations with family, friends, and advocates now is really important, because if you can't advocate for yourself, who will? And that's a big question that you need to consider. So think about that when you're building your support network. Also, too, there are many fine organizations out there that advocate about the rights of people with celiac disease, and are willing to go to bat when you are having problems or obstacles or barriers, or even there as a resource to educate the facilities as to proper ways of handling food, or generally just what your rights are, and having a backup in that way. So building networks with advocates, advocacy organizations, as well as educating your own family and friends as well about what your rights are and what you need in the event that you have to go to these different levels of care for senior facilities. And also too is if everyone in your support network is hitting a brick wall, and you've done everything you could to educate and advocate, then potentially reaching out to an attorney to send a letter, more forcefully explaining what the law is and how they're violating your rights, can be another way to do that. Most people think that, how am I going to contact a lawyer? Lawyers are too expensive. But oftentimes, for a demand letter, or even a lawsuit in these types of cases, a lot of lawyers take these cases on something called contingency, which is something that they only get paid if you get a recovery, if you wind up going to a lawsuit and winning your case. So reach out to attorneys and get that support and have that in your back pocket in case you ever need to get to that point. And hopefully you'll never ever have to get to that point, but it's always good to have attorney knowledgeable on these issues to support you in this area. So those are just kind of a few ideas on building your support network, and I'll turn it over to David John.
Thank you, Andrew. Just to buttress those points a bit further, these are important considerations because when we go into a senior care facility or some other type of related facility, we want to be there for the long haul. And certainly life is unpredictable. If there's cognitive decline or some type of impairment, we want to be sure that we're taken care of going forward. And that's why, as Andrew said, we want to build as many advocates as possible, whether it's a resident advocate or a patient advocate, just even advising the frontline staff and the administrators. Here's who I am, here's what I need. I have celiac disease or some form of gluten intolerance. I need to be sure that I have a gluten-free diet. And, certainly I would like a vast array of options so I can have, nutritionally balanced diet as well. And you can contact a lawyer at any stage and you could advise them, here's my situation, let me know what you think. Oftentimes, lawyers provide a free consultation to hear you out and let you know, here are the steps you can take to protect yourself, whether or not you decide to enter into an attorney-client relationship with that lawyer or particular law firm. So all in all, I encourage all of you, whether it's you yourself or to advise family and friends and loved ones, to build that advocacy network and share as much of your story and your needs as possible to make sure that your needs are met. As Andrew said before, lawsuits often devolve into a he said, she said. And certainly we want you to have as many people in your corner as possible sitting on the sidelines saying, yes, he or she requested a gluten-free diet, requested a modification of the policy, talk to everyone from top to bottom in terms of advising them of what they need, because that's often a refrain we hear from the other side of the lawsuit, from the defendant entities like a senior care facility, is we didn't know. We didn't have enough information. We weren't advised at the time. We didn't know the severity of the condition. We didn't know the precise type of food this individual needed. So the more you can broadcast what you need, the stronger you will be in terms of your legal rights and legal protections in case you need to take the unfortunate step of filing a lawsuit. Now, finally, Andrew and I would like to wrap up with navigating healthcare and legal systems. So I'll turn the floor back over to him.
All right. Thank you, David John. So what do you do, like, for instance, if you get poisoned? What if someone serves you something that they say is gluten-free and in fact not, and you get really, really, sick, and what do you do in that circumstance? And it's just really important that if you ever do get poisoned, that you go to a doctor and you get that documented, because oftentimes a lot of times they'll say, oh, we never served that person anything with gluten in it. They must have just ate some bad food on their own that day or whatever, and then they'll say you can't prove that we were the ones that did this to you or whatnot. And so it's really important that if it ever comes to the point where you do get poisoned, and hopefully that doesn't happen to anyone, because I wouldn't wish that on anybody, make sure you get treatment for that, you document what had happened, and that you communicate with your providers about what happened, your primary doctor, your specialist, and whatnot, because it's really important that that's documented. But regardless, sometimes these entities will ask for documentation about whether you actually are diagnosed or have celiac disease or not, and oftentimes they'll ask for documentation, and so it's sometimes you may have to provide that to get that accommodation, because that's part of engaging in that interactive process. So I know some people may have celiac disease. Some people have various levels of gluten intolerance. And so it's really important to be clear with your providers if you're experiencing symptoms, if they haven't formally diagnosed you in your medical chart yet, to have those kind of conversations with your medical providers so that there's no question in these situations that you are covered under these laws. And so that's something to really be aware of. Now, if you're in a hospital setting, and what are you supposed to do in that setting if you're not getting results? Because oftentimes, you're hurting, you're suffering from your condition, you're in the hospital for a reason. The last thing you want to do is pull up your sleeves and start zealously advocating for yourself when you're just trying to get through whatever you're getting through. And so the easiest way is that most hospitals have something called a patient representative or patient relations or some sort of compliance officer of sorts. And those are the people you should, if you're not getting results from your immediate nurses, doctors, providers, that you should be reaching out to those people and to voice and get your complaint documented. There are magic words in higher levels of care, like nursing homes or in hospitals, is saying that you'd like to file a formal grievance. When you say you want to file a formal grievance, there are a whole host of things that legally the entity is obligated to do, to document, and to conduct a serious investigation that is documented into your complaint. And that's kept on record. A lot of times, if you don't use the word formal grievance, they'll treat it as sort of like an informal complaint where they don't have to go through these mandatory procedures. And so it's really important that you think about those words. If you hit a wall and you say, I would like to file a formal grievance, just remember that if you're in those types of medical settings. With that being said, I'm going to pass off the rest of this to David John.
Thanks again, Andrew. Some parting thoughts before we turn over to the Q&A session. Overall, there's no really good reason to wait to contact a lawyer or to contact a patient advocate or a resident advocate. As soon as you have some type of feeling that you need to advocate for yourself, I would reach out to one of those individuals. As I mentioned before, to file a lawsuit, in case you have to do that, there's often a deadline of 2 or 3 years, sometimes more. Obviously, if you're in a hospital or in a senior care facility and you're actively not receiving gluten-free options and you're being poisoned and your health has been exacerbated tremendously, then you want to move as swiftly as possible to the extent you can. Like Andrew said, you could have a lawyer send a demand letter that's advising the entity of what your legal rights are and how your legal rights are being violated. Oftentimes, if you do have to go through the process of filing a lawsuit, there's relief that you can attempt to seek early on to make sure that you're put in the position that you bargained for. And before the Q&A, that's an important point I want to say. We've spoken a lot about legal mumbo jumbo. I'm sure there'll be a bit more during the Q&A, but most importantly, you want to get what you paid for. And you don't want to have broken promises. If you go to a hospital that tells you that you're not supposed to discriminate on the basis of someone's disability, such as celiac disease, then you don't want to face discrimination on the basis of disability. You want to have gluten-free food. You want to be treated just like anyone else. And the same applies to senior care facilities. So all in all, even though we have all these acronyms, ADA, FHA, what is a disability, what constitutes discrimination, like experience, the overall takeaway is you want to get what you paid for and you do not want to have a broken promise. And that's why it's important to document everything. We'd be happy to talk to you more at a later date, but right now we have the perfect opportunity. So any questions you have, please let us know.
So Andrew, David, John, thank you both for your expertise, your commitment to our community. Yeah, we have a lot of good questions coming in. So I'm glad we're going to take this time to address a lot of these. So I also want to introduce and bring in now at this time, Carla Carter. She's going to join us for our Q&A session. Carla is our Director of Outreach and Programs, she's also an occupational therapist who's worked with adults in geriatrics in various setting since 2002. Here, she oversees our support network, our Feeding Gluten-Free program, and our Support Celiac Seniors initiative. So going to get started with these questions. Welcome, Carla, by the way. We're going to get started with the questions here. And a lot of them, I've kind of put them together. There are some that focus on senior care facilities, or some that focus on hospitals, but I really want to get started with a general one that came in. And it's, could you please address the question of how the ADA might apply to individuals, specifically with NCGS and celiac disease? What medical documentation might be needed in those cases?
Well, I think that if there is documentation of what happens when you consume gluten, or an official diagnosis from your doctor, those are always the two sort of best types of documentation. Even a doctor's letter or note should be sufficient, but something from a medical professional that talks about either your diagnosis or the effects that that gluten does have on you as an individual are probably the two. It doesn't have to be some sort of comprehensive blood study or anything like that. That should be enough. And if they have any reason to doubt that you have this, which they shouldn't, then certainly there could be further questions that are asked. But that's really all you would need. Is a simple letter should be enough.
Okay. Would you recommend any type of support documentation, such as what we have with the National Celiac Association, like on our site, that explains this? Is that helpful from a support organization? Or I mean, I think more the better, but is there overkill in some point?
I don't think there's ever overkill. If you want to,
Okay.
throw the kitchen sink at people, that is, that's great. It's just, making things simple in terms of what the law requires. Law requires is just simply that you put them on notice, that you show that you are a qualified individual with a disability. And so more is always better, but sometimes we get into the situation where you do give tons of documentation and they just keep on saying, well, that's not enough. We need more, we need more, we need more, to the point where it's effectively denying you access by just keep on asking you for more for really no good reason. And so those are situations we want to avoid, where the other side is just not really engaging in good faith, but keeping on asking for more documentation just to delay or deny you access.
Okay. Okay.
If I could,
and then,
Chris,
go ahead, Carla.
sorry. If I could just add real quick to that, once you are in a transitional care facility or long-term care facility, you're also going to want to talk to the registered dietitian there and the covering physician, because it will be helpful for them to then write the doctor's order for you to be on a gluten-free diet, which then adds a level of communication to the kitchen. So that's just the next kind of step, is making sure you pull in the covering dietitian and the doctor at whatever transitional care facility you're in.
Okay, wonderful. Thank you all. Andrew, I'm going to reference back to something that you had said in your presentation and people had questions about. You had mentioned advocacy organizations and professionals who can help you advocate when the celiac person themselves cannot do so. Do you have examples of those, or do you know, how can somebody find somebody like that in their location?
So, really, organizations like yourself, are great resources, and I think that people can reach out, and I'm sure that your organization does have, many different advocates or regional advocates in various areas and whatnot. But to the extent that there's, you've exhausted resources in those areas of reaching out to national and regional and local organizations. There are people in the community, whether it be in celiac disease support groups or local meetups, whether it be in social media, Facebook, things like that, where people who share common experiences kind of join together, and there are resources and advocates in various different states. So that's what I'm talking about when I'm saying that I reach out to organizations or local advocates or people in your area that are knowledgeable about the people's needs in this area.
Okay, thank you for that. So let's dive in a little bit into the different senior care communities. We did have a question I think needs some clarification. Do the laws existing cover seniors living in retirement communities and independent living? Is it regardless of where they are, or the law should cover them in those areas?
Exactly. So there's a common misconception that the law only applies to heightened levels of care like nursing homes or hospitals, but the law does apply to independent living and retirement communities as well. That's under the Fair Housing Act. So, for instance, a lot of senior living communities, they have all these vast menu options and private dining and all these events that they host that have tremendous amounts of food for their residents and things like that. And they need to ensure that all of those things are equally as accessible to people with celiac disease, and that means providing equivalent types of alternatives to things like if they're having steak and crab cakes, or whatever for an event, ensuring that those crab cakes are made gluten-free, so that you can equally enjoy with your co-residents in those areas to get equal access, and they can't charge you extra for requesting those types of accommodations so that you can get access to those foods. The Fair Housing Act is a very strong law, stronger than the ADA and stronger than even Rehab Act and the Affordable Care Act that cover nursing homes and hospitals, because it also provides for an ability to get punitive damages, which the others don't. So to the extent that they are really giving you the runaround or being very nasty towards an individual for just wanting equal access, that they can actually be punished and deterred beyond what the actual damages are in the case. So most people don't know much about the Fair Housing Act and how well it can protect you, and especially in independent and assisted living as well.
So what recourse should one take if the care facility themselves won't accommodate their needs?
Well, first step is, if you exhausted all your needs, all your requests, you've went up all the way up to the chain, the highest you can go. You've reached out to your advocates. Your advocates are having no luck in convincing them otherwise. You should really, reach out to an attorney. And there have been times where I reach out to housing facilities, and they even try to brush me away as an attorney, saying we're not going to do it. And then at that point you have to file a lawsuit and let a judge or a jury decide if the law applies or not. But there are some organizations that no matter how high the chain you go and no matter how many advocates contact them, they're just not going to do it, and they're not going to be compliant with the law. And at that point, you may have to go ahead and file a lawsuit.
So in that scenario, if it got to that point where you do have to sue the care facility, could they discontinue service? Could that senior be asked to leave? Meaning that an eviction is necessary for the resident's health? Is that what happens in that case? I mean, we want to protect the rights of the people who are there, but what happens if can a facility come down and say something such as that?
So luckily, under all these civil rights laws, they also prohibit something called retaliation. To the extent that they and it does happen in a lot of ways when people assert their rights or they file a lawsuit, they may be treated vastly differently, and they may do things to make your life uncomfortable there. But thankfully, the law actually protects you in that circumstance, where if they do engage in any sort of retaliation because of you asserting your legal rights, whether that be kicking you out of the facility or doing anything that negatively impacts you or your health on purpose. There's additional violations that can come from that, and the law provides remedies for things like that as well. So they're actually prohibited by law from retaliating against you because of you asserting your rights.
Okay.
And to add, that's often a concept we talk about in the legal field as pretext. And that's certainly why we want to kind of have a clear documentation in terms of when requests were made, to show a timeline of things were hunky-dory, but as soon as I made a request for accommodation, all of a sudden there were problems that I was experiencing. I was being accused of violating my contract or not abiding by some term of the care facility. And that would help you to shore up information possible, as Andrew said, because the ADA and other laws do protect against retaliation. So in that sense, going back to what we were talking about before with effective advocacy, that's where the documentation helps to show a clear marker of when you made a request for an accommodation or some modification to the policy, and when you were evicted or otherwise put in an uncomfortable situation where you were constructively evicted.
And just to add to that, oftentimes you may not have enough time to wait for a lawsuit or wait for your lawyer to file for an injunction. You just need to get to a safe, environment. And if you do that, I always tell people, because people often ask, it's like, well, what's the best for me and what's the best thing legally? And I always say, take what's best for you first, because if you need to get out of there and you need to be in a safe environment, because if you stay there, any longer, you might pass away there. Get to a safe place first. I mean, regardless of a lawsuit, you can always file a lawsuit afterwards about what all the damage they caused you. But if you need to take care of your health and you need to go to a different facility because that's what's best for you in that moment, feel free to do that.
Okay. It's good advice to take there. So I do want to go back. I know you addressed this in your presentation, but we hear so many times about situations where people are being asked to pay extra fees or charged extra rent to accommodate the gluten-free diet. I just want to touch on that again. That is not something that is that the facilities are allowed to do, correct?
Yeah, that is completely impermissible for them to do that because essentially they're giving you a disability surcharge, essentially. And so it's making living at that facility more costly than if you didn't have a disability. And that's impermissible. From some sort of a business perspective, one could think, oh, that makes sense because they're spending extra money on additional food, so you have to pay extra money. But it's actually not correct under the law that they require that, because accommodating people with disabilities does cost money, and it is the facility's obligation to incur those costs as a cost of doing business, and so it's up to them to ensure that they're charging the same prices to you as anyone else.
Okay. I do want to get some questions about hospitals. We've had some come in over the chat. We did also have a registered nurse who chimed in and asked, as a nurse working in a hospital, how can she or he best advocate for their seniors with celiac disease in the hospital setting?
I think that's great, and I think going to your supervisors and encouraging training of staff, even offering to help lead that training amongst staff and share your knowledge and your concern and your care about this issue could be a really great way of advocating amongst your organization, because education is power. And if you and if your coworkers are educated on these issues, you'll all be better for it. So that is something. But if there's a point where you feel like your direct supervisors are against you and while you're advocating for people with celiac disease, again, go up all the way up the chain, go to the administrator, CEO, if you have to, and advocate for people's rights if you feel like they're not being taken care of appropriately. But hopefully, the education route and would be the best way of just getting everyone on board and being willing to do the work within your organization to provide that education and advocacy to your fellow coworkers. I think would be a great way of having a start there.
And what's more,
Okay.
documentation, as we've said, is often very vital. So for the registered nurse, many times in a hospital, there's a document that could be known as a plan of care form, or it goes by some other name, in which every time the baton is passed from one nurse to another or to a doctor, it's displayed key points for that patient. I think that could also be a good spot to mark this patient requires a gluten-free diet or some other alternative, additional documents, just so that's memorialized and in paper form. So even if you can't go to all your coworkers from A to Z, at least you have something that should be read every time they interact with the patient. And again, that just shores up the possibility that there'll be a gluten-free diet and accommodations at every turn.
And I have one more thing to add, Chris. On our website, we have a senior landing page where we in the past have done a webinar about operational considerations in the kitchen around senior care facilities. So that is a resource for you. And I know Chris said we were going to probably do a follow-up email with the link for this recording, so we can also put those links directly in the follow-up email as well.
Yeah, thanks, Carla. That it's a good reminder that we do have resources on our site, and we will send those out to you with this recording. And as we look at the time, I knew we'd have so many questions, and we're running short. So I want to ask one more that we have before we do some final statements. And this is from somebody. Any suggestions for those people who have more than one ADA accommodation diagnosis? I'm sure you've run across that, but are there certain things that might get a better consideration than others? You don't want to say it that way, but the fact of the matter. So is there anything around that, any suggestions for those people who have multiple ADA needs?
Yeah, I think that, a lot of the principles that we talked about documentation and advocacy and going up the chain and things like that are applicable to all sorts of different disabilities. And I think that the principles that we have talked about in this webinar are directly can be directly applied to pretty much any sort of disability. And so I suggest that using the tips that we've learned here today about how to self-advocate and relying on your advocacy networks are going to be useful tools, whether you just have one disability or you have multiple disabilities, because I don't think that in terms of how you should advocate for yourself in these types of care settings really changes all that much. It's just the content of the education and the substance of whatever request you're making for accommodation. But even if you have multiple disabilities, it's important that all of your disabilities are taken care of, not just one or the other.
Indeed, the common refrain from today is full inclusion, ensuring that you are treated the same way as individuals without disabilities, whether you have celiac disease, a service animal, you're deaf or hard of hearing, or blind or in a wheelchair, you should be treated the same as everybody else.
And David John, I think that's a great final takeaway from this. We cannot thank you both enough. Andrew, David John, Carla, thank you for taking time out of your busy schedule. There's a lot of questions we didn't get to, so I really think we have the potential of doing a follow-up webinar and really addressing some more of those questions, because there's a lot of information out there that is great to be shared, but there's more questions that people want to have answered. So, we appreciate what you're doing, your support, and you're fighting for the rights of our seniors and the celiac community in general. So thank you both again for that time today.
Absolutely. It's our pleasure. And if anyone has questions, we can share our contact information after the webinar, and we're happy to answer them directly for anyone that has any burning questions that were not answered here today.
Yeah, and we can also include that contact information within that email that we send out to everybody, just so they have that there in their inboxes. So
Wonderful.
I appreciate it. Well, thank you both again. And another thank you to all of you who attended and participated today. We hope the presentation answered some of your questions and provided you with helpful information about your legal rights. Remember, you're going to get that link in a couple of weeks, and you'll be able to reference that in the future if you want to look back and rewatch this webinar and get some more information. Continue to visit our website and our social media accounts here at NCA for updates about future programs. Presentations, maybe a follow-up to this one, that's going to help with your personal empowerment. And so for Andrew and David John, Carla, myself, the entire team here at the National Celiac Association, we thank you for taking part in today's event, and we want you to have a wonderful remainder of your day.
Thank you, everyone.
Thank you.
Thanks all.